The most powerful man in NASCAR did not walk into that courtroom expecting to lose control of the story. For more than 7 decades, control has been the France family's greatest strength. They controlled the tracks, they controlled the schedule, they controlled the money, and most importantly, they controlled the narrative. But inside a federal courtroom in Charlotte, that control quietly began to slip away. This was not just another legal dispute. This was not 2 unhappy teams arguing over fine print. This was a direct challenge to the foundation of how NASCAR has operated for generations. On one side sat NASCAR, the sanctioning body that built the sport into a multi-billion-dollar empire. On the other side were 2 race teams willing to risk everything to question that power structure publicly. Michael Jordan's 23XI Racing and Front Row Motorsports were not just suing for better terms. They were asking a federal court to examine whether NASCAR's system itself crossed a line. And when the witnesses were called, what happened inside that courtroom stunned nearly everyone watching. Pressure was quietly building long before Jim France ever took the stand. At 80 years old, France is not just NASCAR's chairman and CEO. He is the living symbol of the France family legacy. His father helped shape stock car racing into a national phenomenon. His family has overseen the sport for more than 75 years.
Jim France rarely speaks publicly, rarely gives interviews, and almost never faces unscripted questions. But in court, there are no scripts. When he raised his right hand and swore to tell the truth, the tone of the trial immediately shifted. Lawyers for the teams did not waste time with broad questions. They came prepared with emails, documents, timelines, and specific moments from NASCAR's charter negotiations. These were not casual conversations. These were decisions that determined whether teams would survive or disappear. The first questions sounded simple. Did France remember the details of the charter negotiations? His response echoed through the courtroom. He said he did not recall. The lawyers followed up with more precise questions. Meetings, deadlines, emails bearing his name. Again, France said he could not remember. Sometimes he said maybe. Sometimes he said he was not sure. Rarely did he give a firm answer. People watching could hardly believe it. This was the man who ran NASCAR, the man whose signature authority guided the entire organization. Yet, under oath, his memory seemed to vanish when the questions mattered most. As documents were placed in front of him, the tension only grew. Emails connected directly to him were shown. Lawyers asked whether he remembered sending them or reading them. France hesitated. He struggled to provide clarity. His answers were careful, measured, and distant. To legal observers, it did not sound like confidence.
It sounded like caution. Then came the moment where the conversation turned from memory to power. France was asked about NASCAR's negotiating strategy with teams. He stated that teams had a choice. He said NASCAR was not forcing anyone to sign. According to him, teams were smart business people who understood the deal. If they didn't like it, they could walk away. That argument might have held weight if not for what came next. Lawyers introduced documents showing a hard deadline. Teams had until September 6th at 6 in the evening to sign the charter agreement or lose their charter entirely. The lawyer asked a simple but devastating question. Did that really sound like a choice? France attempted to defend it. He explained that deadlines are part of business. He insisted the deal was fair, but his voice lacked conviction. The room could feel the discomfort. This was no longer about abstract principles. This was about leverage. Then the lawyers turned to one of the most controversial parts of the contract, a clause requiring teams to agree never to sue NASCAR. France was asked why such a clause was necessary. What was NASCAR afraid of? France responded that it was standard business practice. He said NASCAR wanted long-term stability. But the lawyer pressed harder, pointing out that most partnerships do not require one side to permanently give up legal rights. If the agreement was fair, why demand immunity? France denied any fear of lawsuits.
But he could not clearly explain why such extreme protection was needed if everything was balanced. From the bench, Judge Kenneth Bell had been watching closely. At several points, he interrupted the testimony. He asked France to answer more directly. He made it clear that "I don't recall" would not be sufficient for certain questions. Judges rarely step in like that unless credibility is becoming an issue. Then came a moment that rippled far beyond the courtroom. NASCAR's lawyers repeatedly objected to questions, trying to slow the momentum. Judge Bell finally responded with a sarcastic apology. His tone made it obvious he was not apologizing at all. He was signaling frustration. To legal analysts, that moment mattered. Judges are trained to hide emotion. When irritation shows, it usually means one side is losing patience from the bench. For NASCAR, it was a troubling sign. After nearly 2 hours of tense testimony, Jim France stepped down. By then, the damage had already been done. The most powerful man in the sport had appeared uncomfortable, evasive, and unprepared to defend the most important business decision NASCAR had made in years. And the day was far from over. Next came Steve Phelps, NASCAR's president and chief operating officer. Unlike France, Phelps lives in the day-to-day reality of the sport. He was deeply involved in the charter negotiations. If anyone could explain NASCAR's position clearly, it should have been him. At first, Phelps spoke confidently.
He explained that NASCAR had worked with teams throughout the year. He said input was gathered, ideas were discussed. But then he admitted something critical. In September, NASCAR presented what it called its final offer: take it or leave it. The lawyer asked how much room there was to negotiate after that point. Phelps admitted there wasn't much. NASCAR had made its decision. The terms were set. Then the conversation shifted to Michael Jordan's team, 23XI Racing. When Phelps talked about those negotiations, his demeanor changed. He described the process as frustrating. According to him, 23XI kept pushing back. They wanted changes. They wanted more revenue. They wanted different rules. The lawyer asked why that was frustrating. Was it because the team was being unreasonable, or because NASCAR had already decided it was done negotiating? Phelps paused, then answered honestly. He said it was frustrating because NASCAR had already decided the terms. That single sentence changed everything. The lawyer followed up immediately. If NASCAR had already decided the terms, was this really a negotiation, or was NASCAR simply informing teams of the outcome? Phelps tried to explain that NASCAR had listened earlier in the year, but when pressed, he admitted that very few team suggestions made it into the final agreement. Most of the contract reflected what NASCAR wanted. Then came the money. Teams had been pushing for a larger share of NASCAR's revenue.
The lawyer asked whether NASCAR seriously considered it. Phelps said they did, but ultimately decided against it. NASCAR believed the current split was fair. Comparisons were introduced. In the NFL, teams receive nearly half of league revenue. In the NBA, it's about the same. In NASCAR, teams receive roughly 25%. Why the difference? Phelps explained that NASCAR owns the tracks, NASCAR promotes the races, NASCAR shoulders more responsibility than other leagues. Therefore, NASCAR deserved a larger share. But the lawyer pointed out the other side of that argument. If NASCAR owns the tracks and controls the series, teams have nowhere else to race. There is no competing league at the same level. That structure creates dependence. Phelps disagreed. He said teams benefit from the system. He pointed to rising charter values as proof that teams were doing well. Then the lawyer asked a quiet but powerful question. If teams are doing so well, why have so many shut down in recent years? Phelps did not have a clear answer. He said racing is expensive. He said some businesses fail, but the explanation felt thin. After Phelps stepped down, the courtroom took a break. Observers whispered. Reporters typed furiously. It already felt like NASCAR was on the defensive, but no one expected what happened next. Richard Childress walked to the witness stand. Childress is not just another team owner. He is NASCAR royalty, a champion owner.
A man whose reputation is built on decades of loyalty to the sport. And unlike the teams suing NASCAR, Childress signed the charter agreement. That made what he said next even more powerful. When asked how he felt signing the agreement, Childress paused. Then he said he felt blindsided. The room went silent. Blindsided from a man who agreed to the deal.
Childress explained that the process moved faster and harder than he expected. The deadline pressure was intense. He said he felt boxed in. The lawyer asked why he didn't simply refuse to sign, like 23XI and Front Row Motorsports. Childress became emotional. He explained that refusing would destroy everything he built. His team employs hundreds of people. Sponsors depend on his participation. Drivers' careers depend on having a place to race. Walking away wasn't just a business decision, it was a collapse. He admitted that even though he believed the contract wasn't fair, he signed because the alternative was unthinkable. Then came the question that landed hardest of all. Did he feel pressured by NASCAR? Yes, Childress said, absolutely. By the end of the day, the narrative had completely flipped. Jim France struggled to explain decisions. Steve Phelps admitted negotiations were effectively over before teams signed. And Richard Childress, NASCAR's own ally, testified that he felt forced into an agreement he didn't believe was fair. This trial is no longer just about contracts.
It's about whether NASCAR's model depends on leverage so strong that teams cannot realistically say no. What happens next could redefine the balance of power in the sport. The charter system, once marketed as stability, is now being examined as a potential restraint. And for the first time in decades, NASCAR may be forced to defend not just its decisions, but its identity. Because once power is questioned under oath, it never feels the same again.